Great. Thanks, Colleen. Can you hear me?
Yep.
Okay,
Yeah,
perfect.
sound good.
Okay. Thanks, everyone, for joining us. As Colleen said, this is a webinar entitled Landlord Tenant Law and Critical Changes That Will Affect Victims of Domestic Abuse. Today, we've got a lot of material to cover. We're going to focus on Wisconsin Act 176, which is a new landlord tenant law that made a couple of significant changes for victims of domestic violence. In particular, it has a provision that allows landlords to terminate tenancies for criminal activity in an expedited fashion, and it contains a provision that requires police departments to have policies for investigating trespass complaints and removing trespassers to dwellings. So those will be the focus of our presentation and the implications around those provisions, things that you can do to mitigate the negative unintended or negative impact for survivors. But before we get to that, I want to provide a little bit of context into landlord tenant law so that you kind of understand how these things are situated, and take this as an opportunity to do a refresher on DV-specific landlord tenant laws that are already in existence. So we'll try to move through these sections as quickly as we can so we have time to focus on the new law, Wisconsin Act 176. So getting right into landlord tenant basics, and I should say this is meant just as a summary to provide context. If you have specific issues about landlord tenant law in particular cases, always feel free to reach out to us at End Domestic Abuse Wisconsin, and we'll try to answer those questions or point you in the right direction. But just again, basics, there are three types of tenancies in the state of Wisconsin. There are tenancies that are created between a landlord and a tenant through a lease. And when lease is used in this context, it means a rental agreement for a definite period of time. The most common type of lease would be a year-long lease. It starts on one day in the first year and then ends on that day in the following year. And rent is paid monthly, but it's understood that the lease period will be for a certain amount of time, most commonly a year. The second type are periodic tenancies. That's where there's not a definite amount of time set, but more like regular and reoccurring intervals of paying rent. There may be written agreements, but there isn't that definite end point. So most commonly this is a month-to-month type situation where rent is due on the beginning of the month, and as long as the tenant keeps paying and the landlord wants to continue that arrangement, it goes on indefinitely. The third type of tenancy is what's called a tenant at will. And this is maybe less understood or less known about, but it is a type of tenancy that's recognized under Wisconsin law. And it occurs when a tenant or a person who is in possession of a residential property is staying there without necessarily paying rent or having a written lease, but with the permission of the landlord. And so what this means is that someone who may not necessarily be recognized as a tenant, kind of in the common sense of the word, but who has a residence in a home and has established that residence with the permission of a landlord, has rights under Wisconsin law. And we'll talk a little bit more about that in the context of Act 176 in a minute. Another just kind of landlord-tenant basic that I want to emphasize is that rental agreements can be both verbal and they can be written. So the statutes recognize that landlords and tenants come to verbal oral agreements and that those are valid ways to create a landlord-tenant relationship such that both parties have rights and responsibilities. So we've talked a little bit about tenancies. Let's talk about how tenancies are terminated. And there are kind of two categories that we'll talk about, the first of which is those terminations that aren't for cause, right? If either party wants to just end the landlord-tenant relationship, how does that work? And with a lease, it works that it happens at the end of the lease period. For periodic tenancies, there are particular types of notice that are required. And generally speaking, so if you have a month-to-month rental agreement, for example, the notice to end that must be written. It must be given at the end of the rental period. So if rent is due on the first of the month, towards the end of 1 month would be the time to give notice, and then that notice must be at least 28 days in length, normally if we're talking about a month-to-month situation, or if, say, rent is paid on a more frequent basis, the amount of time that constitutes that rental period, so like week to week or every other week, or some other method that is agreed to by the parties and that is explicitly agreed to by the parties. So practically this means that if someone has a month-to-month lease or tenancy, that there's at least 1 month's notice before that relationship ends. And these same notice requirements are true of tenancies at will as well. So a situation where someone is a tenant at will because they are staying in a dwelling with the permission of a landlord, they have to be given written notice, and they have to, that notice has to be of a certain length. And if rent isn't being paid at all, then that has to be at least notice equal to 28 days, unless there has been some other method that the parties have agreed to. So that means that tenants at will, folks who have established a residence with the permission of a landlord, can't just be forced to leave at the whim of a landlord, that there are particular notice requirements. And that will become important when we talk about Act 176 as well. So those are, we're talking about terminations not for cause. Now let's talk about terminations for reasons of non-payment of rent or for breach of leases. And the kind of just important concept that I want to highlight here is that when an individual has a lease, so not talking about periodic tenancies, but month to month or week to week, when someone has a year-long lease, typically for non-payment of rent or for breach of the lease, they have to be given a 5-day notice to either pay rent or to cure the breach, the violation that of the lease that they've committed or allegedly committed. So that 5-day notice affords an opportunity to make the situation right. And what that may mean in a particular circumstance, depends on the facts and circumstances. For example, if it's a violation of the lease to have a pet in the apartment, and the landlord notices that and gives the tenant a 5-day notice for violation of that lease condition, removing the pet from the apartment more or less would typically be curing that breach. So kind of built into the process here, there's that one opportunity to make the situation right. However, if someone who has already received a 5-day notice for non-payment of rent then doesn't pay rent at the time which it's due, the landlord has the option to, if that previous violation was within a year, has the option to give a 14-day notice which terminates the tenancy. And the same is true for violations of lease conditions. The important point is that typically when someone has a lease, that they have an opportunity with the 5-day notice to correct a situation. When we're talking about month-to-month or week-to-week tenancies, the landlord has the option to give that 5-day notice and give the tenant the opportunity to pay rent or cure, but also has the option to terminate the tenancy with a 14-day notice right away, skipping that step. just in terms of basic terminology and concepts, I want to point out that eviction and termination of tenancy, which we've been talking about in terms of these notices, are distinct concepts. And sometimes they're used interchangeably, and I may find myself accidentally using the terms interchangeably during this presentation. I'll try not to do that. To be precise, eviction is a court process to remove a tenant who has held over after the termination has occurred, after proper termination. So after, for example, those 14 days have run, after a properly served notice to 14-day termination notice, if the individual is still in the unit, eviction is the court process by which a court determines that the tenancy has been properly terminated and then orders the sheriff, if appropriate, to remove the tenant from the property. And the eviction process through the courts and then affected by the sheriff is in almost all cases the only lawful way to remove a tenant from a rental property. Landlord tactics such as changing the locks or trying to turn off the utilities, those tactics are typically called self-help evictions, and those are almost always unlawful. Okay, so those are just some basic concepts related to landlord tenant law that will kind of apply later that I wanted to set the stage with. I also said that I wanted to take some time to review landlord tenant laws that specifically relate to domestic violence. And we've done at NW's other trainings and produced materials on these. So I'm not going to go into great depth with any one of them. But like I said, I think this is an opportunity just to make folks who might not be aware of these laws and to explain how they might relate to the issues that we're seeing under Act 176. The first thing that I'll talk about is the Wisconsin Safe Housing Act. And this is a law that has three main components to it. It allows victims under certain conditions to terminate tenancies so that they are able to flee from situations that they're unsafe in. So if they are unsafe, if it would be unsafe for them to remain in a rental unit because of threats or stalking, there's a process by which they can terminate that tenancy if they have certain documentation. A separate provision allows landlords to terminate the tenancy and evict abusers if certain conditions are met without necessarily evicting or removing co-tenants. So the idea here is that the landlord can remove an offending tenant without necessarily evicting tenants who have not been abusive or are not causing the safety concern. And then thirdly, the Safe Housing Act renders unenforceable leases that allow landlords to penalize tenants for calls to emergency services. And I won't go too far into all the ins and outs of this law, other than to explain that what is generally required for a victim to terminate the tenancy is notice to the landlord, certified copies of certain official documents, which there'll be a list of in the handouts, and the existence of an imminent threat to the physical safety of the victim or the victim's child. And the way that this works is that if the victim has one of these official documents, and generally we're talking about restraining orders, or excuse me, I should say injunctions, that protect the victim or the victim's child from the person who's causing the threat, or criminal complaints that allege that the person who's causing the threat committed sexual assault, stalking, or domestic abuse against the victim or the victim's child. If those conditions are met and the tenant qualifies for the protections of the Safe Housing Act, the tenant is not liable for rent in the month after. I should just read the statute here because it's a little confusing. The tenant is not liable for rent after the end of the month following the month in which he or she provides notice. So more practically, if a tenant provides the documentation and the notice on October 11th, potentially the tenant is liable for November's rent, but not December's. And so it provides some protection and some ability to not face ongoing liability for having to relocate. This is a law that we get questions about periodically, and I think it's fairly well known about and utilized on a somewhat regular basis. But if you have any questions about that, feel free to contact us at End Domestic Abuse Wisconsin. I also mentioned that the Safe Housing Act renders unenforceable and void leases that allow landlords to take adverse actions against tenants for calling emergency services. The idea there is that survivors of domestic violence, and really anyone, should always be able to contact police when they have safety concerns or they need emergency care. Another provision of Wisconsin Landlord Tenant Law that folks may not know about as much is that in certain situations, landlords are required to change the locks or give the tenant permission to change the locks when someone is a victim of domestic abuse, sexual assault, or stalking, and they have that documentation that would qualify them to use the Wisconsin Safe Housing Act. So that's, I just wanted to mention that. We don't need to go into great detail about that, other than maybe I'll mention that that lock change or permission for the lock change will have to occur within 48 hours of notice when the landlord is provided with that information. And again, the documents that I mentioned in the context of the Safe Housing Act are also applicable to this provision that allows for lock changes. All right. I also want to talk about the Wisconsin Victim Fair Housing Act. This is a law that has two main components, and it applies to all residential housing in the state of Wisconsin. The first component is a non-discrimination provision, which says that landlords or other housing providers cannot take adverse actions against someone based on their status as a victim of domestic violence, sexual assault, or stalking. So, for example, if a landlord were to know that someone who's applying to rent an apartment was previously a victim of domestic violence and says, oh, is there going to be trouble in my apartment building? I don't want any of that kind of trouble. I don't think I want to rent to you. That would be illegal housing discrimination. And it's equivalent to discriminating against someone based on their race or religion or ethnicity in terms of housing decisions. That's one provision. The second provision is an eviction defense. And it says that it's illegal to evict victims of domestic abuse, sexual assault, and stalking when the basis for that eviction is conduct related to the commission of those crimes. And the conduct was committed by a co-tenant or a person who is not an invited guest of the tenant, of the victim of those crimes. There's another kind of caveat to that, or I should say a separate analysis if the person who committed the crimes that formed the basis for the eviction was an invited guest. In that case, it still could be illegal to evict the tenant, the victim, if the victim has sought a restraining order or provided written notice that this person who was an invited guest who was abusive will no longer be an invited guest. And so that may be applicable in some of the situations that we'll be talking about under Act 176, so I want to mention it here. With the Victim Fair Housing Act eviction defense, the tenant has the burden to prove that the conditions of the law are required, so the burden of proof falls on the person who's trying to claim the protection, the tenant, the victim. And the tenant must show that the landlord knew or should have known that the basis for the eviction was domestic violence. Lastly, I just want to mention, again, a provision in our law that I think is maybe not as well known about, and that is that all residential lease agreements in the state of Wisconsin are required to provide very explicit notice of the protections under the Victim Fair Housing Act and the Safe Housing Act. It's a relatively recent change in the law, but all residential leases should have that information that apprises tenants of their rights and protections should they be victims of domestic violence, sexual assault, or stalking. And what's more, leases that have any provisions related to terminating tenancy in relation to the commission of the crime, those leases, if they say anything about terminating tenancy for criminal activity, they are void and unenforceable unless they have that specific notice of the victim protections included in the leases or in a lease addendum. And so that means if those notices weren't included by the landlord, the tenant may have significant leverage over the landlord depending on the facts and circumstances. Okay, so that was just our kind of very quick basic run through some landlord-tenant concepts and some specific laws that relate to domestic violence. I'll note that there are similar protections in federal law for federally subsidized housing. We don't have the time to go into those into any great detail. In many cases, they are very similar or mirror the state laws that we've covered here, like the Victim Fair Housing Act. And so if you're working with a client who is in federally subsidized housing, you might want to look at both sets of laws and determine which might be the most advantageous to work with in that particular situation. Okay, moving to our main topic, 2015 Wisconsin Act 176. Here's a copy of the act. It's probably one of my least favorite laws, and that will become clear as I talk to you and describe some of the provisions. It was signed into law late February of this year and went into effect this spring, and so it's relatively recent. And landlords, law enforcement, and attorneys, courts are still grappling with a lot of the provisions contained in the law, trying to make sense of them. We're going to focus on the two provisions that I talked about. A provision that allows for 5-day terminations for criminal activity, and then a second provision that requires law enforcement agencies to have written policies regarding trespass violations and or investigations into trespass violations, and that those policies have kind of like a mandatory arrest or removal element to them, that the policies state that officers who have probable cause to believe someone is committing trespass in a dwelling, that they have to arrest or remove that person from the dwelling. So let's focus first on the 5-day termination for criminal activity. What this provision says is that a tenancy may be terminated with this 5-day no-cure notice if criminal activity is committed by any of the following: a tenant, a member of the tenant's household, or a guest or other invitee of the tenant, or a guest or invitee of a member of the tenant's household. So practically speaking, if say a mother and a teenage son live in a rental home, and the teenage son has a friend over who commits criminal activity that the mother didn't know about, it's entirely possible that the mother's tenancy could be terminated as a result of that on a 5-day basis, and that the mother, the tenant in this scenario, has no ability to to cure that problem, or doesn't get a second chance. So the type of criminal activity that qualifies for this 5-day termination is not any criminal activity. There are some limitations on it, and that's what we'll talk about right now. We're talking about criminal activity that threatens the health or safety or right of peaceful enjoyment of the premises by other tenants. So if the criminal activity interferes with the health or safety or ability of other tenants to peacefully enjoy their homes, or has that effect on persons who are residing in the immediate vicinity of the premises. So like neighbors in other homes or rental units around the apartment or rental home. Or if this criminal activity threatens the health or safety of the landlord or employee of the landlord. So there's some limitation on it, but as you can probably guess or imagine, these standards are somewhat vague, and it'll be arguable in any particular case whether criminal activity rises to this level. In addition, there's another type of criminal activity that is eligible for the 5-day termination, and that is criminal activity that is drug-related. And the legislation defines this as criminal activity, again, committed by one of those 4 types of individuals that we talked about: tenants, household members, or guests, and drug-related criminal activity that occurs on or near the premises. Drug-related criminal activity is further defined as criminal activity that involves the manufacture or distribution of a controlled substance. So it's somewhat notable that possession is not included here, and I think that might be a limitation in some situations. I think it'll be this will be applied in a variety of different ways. And some landlords may not actually kind of take the time to investigate what drug-related criminal activity means, and may try to use these 5-day no cure terminations for cases of use or simple possession without distribution or manufacture. So that's something to pay attention to. Before we move on, I should say that criminal activity under this provision does not need to be criminal activity that results in an arrest or a conviction or a charge. It's sufficient that the landlord alleged that the criminal activity occurred, and if and when an eviction action goes to court, that the landlord is able to document and prove that the criminal activity occurred. So it can occur in a variety of situations. Even if the police were never called, as a technical matter, landlords still have the opportunity, if they believe that criminal activity occurred, to use one of these 5-day terminations. So now we're going to be talking about a relevant exception to the 5-day termination. And that is an exception that says that under the law that we've just been talking about, the tenancy of a crime victim cannot be terminated. So landlords may not use this 5-day no cure termination process on crime victims. Now, the definition of crime victim that is used in the law is the same definition of crime victim in the Crime Victim Rights chapter of Wisconsin Statutes, Chapter 950. We won't go into the details of that definition, but probably the most relevant and applicable part of that definition that will be relevant and applicable to this situation is that victim is defined as the person against whom the crime has been committed. And so what that means is that to utilize this exception, the tenant will have to be the victim of the crime that the landlord is alleging is the basis for the termination. So if, for example, the landlord is alleging that the crime that's the basis for the eviction is property damage that occurred on the property, and that somehow rose to the level of affecting the peaceful enjoyment of other tenants. If the other tenant who's trying to claim this exception wasn't the victim of that property damage, then they may not be able to assert this exception, even if they were a victim of abuse perpetrated by the individual or the co-tenant who committed the property damage. Also, critically, victim in this context does not include the person charged with or alleged to have committed the crime. So that may become a limitation or a factor when survivors of domestic violence are charged with crimes related to their abuse. So moving now from that exception to what notice is required for landlords to use this 5-day termination process. The notice of the 5-day termination must state the basis for its issuance, which means that the landlord cites the statute in Act 176. The landlord must include a description of the criminal activity or drug-related criminal activity, including the date and the identity of the persons or description of the persons that the landlord is alleging committed that activity. The notice also has to say that the tenant has the right to contest the allegations before a court commissioner if the landlord goes through with the court eviction process, and it includes some language that directs tenants that they have that they can hire an attorney, basically seek assistance from a volunteer legal clinic or a tenant resource center. So that's the notice that's required. Now I want to talk a little bit about the process of potentially contesting a 5-day termination for criminal activity. So as we just said, the tenant has the right to contest this if the eviction action is filed, and the landlord would have the burden of proof to prove that the requirements of the statute are fulfilled and the criminal activity was committed by one of the 4 types of individuals that qualify. In order to contest the termination, if the tenant is planning to stay in the unit pending the eviction process, there may be financial consequences for unsuccessfully contesting the termination, such as damages for holding over. And I think it's also just important to always point out that the client may want to have an attorney for this particular process because this is a new law. It may be very complicated whether the exceptions apply or whether the requirements of the statute have been met. Courts will be applying this law for the first time, and it may be to the client's benefit to have an attorney if that's at all possible. In the context of potentially contesting a 5-day termination for criminal activity, I think it's important to look both at the crime victim exception that we just talked about, but also the eviction defense in the Victim Fair Housing Act. The Victim Fair Housing Act eviction defense might be broader and include some situations that the crime victim exception does not. Because the Victim Fair Housing Act eviction defense says that it applies to evictions that are based on the commission of crimes related to domestic violence, sexual assault, or stalking. There's, I think, maybe a little bit more flexibility in how that could be applied in situations where the landlord is alleging a crime occurred that the victim wasn't, that the client, the victim of domestic violence, wasn't necessarily the victim of the crime that the landlord is alleging. So again, if the landlord is alleging a crime like disorderly conduct or property damage, and it's not clear that the victim of domestic violence was the victim of that crime, if the crime is still related to the commission of domestic violence, it's possible that the Victim Fair Housing Act is a viable defense. So that's just to say, depending on the facts and circumstances, consider both of those provisions. So I think having talked about the 5-day termination, it's helpful to just take a step back and think about what this means in reality. It means in reality that tenants will be faced with these types of notices under what might be very stressful and already traumatic times if criminal activity took place in and around their home. And so I think it's fair to say that clients will have a lot of different and various reactions to that. And some clients may feel able to research the law and understand exactly what happened and reach out to either a domestic violence agency or to legal action and try to fight what has happened to them. Others may panic because what they're being told is that they have 5 days to find a new home, or at least that's what it appears like to them. And so if you're working with survivors who have been served with one of these 5-day terminations, I think it's important to try to gather as much information as soon as possible. If you're able to get a copy of the notice to understand exactly what's going on. And as soon as possible to make the client and the landlord, either through the client or if you have a release and permission from the client to speak to the landlord, do it yourself, to make the landlord aware of possible exceptions and defenses as soon as possible. Anytime the client or as an advocate you are communicating with the landlord, I think it's a good idea to, if it's possible, get those communications in writing or at least memorialized in writing, because it may be that we end up in an eviction action in court, and what was said to whom and what all transpired might be relevant. And again, I think these are very fact-specific and complicated situations potentially, and so if it's possible to obtain counsel, I think that should be a focus. I know that it's not always possible, but what's at stake here is the housing stability of a survivor. Someone may be forced to leave what is their home on a very short and expedited basis. So as much information and clarity and options that can be brought to bear to that situation as soon as possible is going to be to the benefit of the folks that you're working with. So that is the 5-day termination for criminal activity. I'm going to shift now to talking about this other provision of Act 176 that relates to the removal of trespassers by law enforcement. And that's pretty much verbatim a copy of the provision right there. As you can see, law enforcement agencies have to develop these written policies regarding trespass complaints, and that when they have probable cause to think someone is trespassing in a dwelling, that they arrest that person. This was passed with the declared intent of trying to deal with squatters and landlord groups saying that they found that police were not dealing with individuals who broke into rental units and tried to establish a home in those rental units, and they felt that police should be more active in those types of situations that are typically referred to as squatting. So I have here the criminal trespass statute, And so remember, police under this law are required to arrest individuals they have probable cause to believe are committing this crime in a dwelling. And the essential kind of components here are that the person who is allegedly committing the crime has to intentionally enter or remain in a dwelling of another person without the consent of a person lawfully present. Or if no person is present, and I think this was meant to address these squatting situations, without the consent of the owner of the property that includes the dwelling. And critically, all of this must be occurring under circumstances that tend to create or provoke a breach of the peace. Excuse me. So why are we talking about this provision? The reason we're talking about this is that we've been made aware at End Domestic Abuse Wisconsin of a few situations. I hope they're isolated, but I fear that they're not, where law enforcement is called into homes and either for domestic violence situations or for other reasons. And in the course of interacting with the folks who live in that home, they learn that someone is not on, quote, not on the lease, that they're staying there, if they had been staying there with the permission of a person who is on the lease. And then law enforcement says to the person who is supposedly not on the lease, that the law changed and you need to leave. In one situation that we know about, a victim of domestic violence called the police. The perpetrator was arrested, but when the police learned that the victim was not on the lease and that the perpetrator was, they told the victim that she had to leave what she thought was and believed to be her home. And that's what she got for calling the police to protect herself against a perpetrator of domestic violence. So the potential for police interpreting this provision broadly and using it in ways that cause all kinds of problems for survivors is, there's a huge potential there. And so that's why we, I think, need to kind of look at it and tease it out and understand exactly what it means. So first, I think it's helpful to talk about who is not a trespasser, right? Who clearly is someone who should not be being removed under the provision that we're talking about here. So tenants are not trespassers. They are people who, by definition, have a legal right to be in the home, unless, of course, there's some kind of restraining order in place. But generally speaking, tenants are not trespassers. So a tenant who has a written rental agreement is not a trespasser. A tenant who has a non-written, an oral rental agreement is not a trespasser. And further, someone who is a tenant at will, which we talked about earlier, is not a trespasser. There's someone they are an individual who has a legal right to remain on the property. And unless their tenancy at will has been terminated via the notice process that we discussed earlier, which is in probably most situations going to be a 28-day written notice process, they cannot be removed, or they're not trespassers, and they should not be removed from the residence. Just a reminder that a tenant at will is someone who is residing at the property with the permission of the landlord, who established the residence on the property with the permission of the landlord. Further, someone whose tenancy has been terminated but has not been evicted and has not been removed by the sheriff through the eviction process is not a trespasser. They're a holdover tenant, and the law recognizes that the only way in which they can be legally removed from that property is via the civil eviction process. And the reason that that's important is that in some of the scenarios that I was just talking about, where perhaps a survivor of domestic violence is staying in a residence but is not on the lease, law enforcement may not be able to ascertain whether that person, whether or not that person is a tenant, either a tenant who has a nonverbal and oral rental agreement that was established between that person and the landlord, or someone that the landlord at one point gave permission to have a residence there, to hold the property. So I want to just kind of emphasize these misconceptions about who is and is not a trespasser. If an individual is not on a written lease, that person may still be a tenant, and the absence of the person's name on the lease is not proof that he or she is a trespasser and subject to the quasi-mandatory removal provisions of Act 176. Further, it's a misconception that the police, talking here about law enforcement officers who are not sheriff's deputies executing writs of restitution under the civil eviction process. Normally, law enforcement officers cannot evict someone. Eviction is, as we've been saying, a court process that concludes with the sheriff being ordered to remove a tenant. And other removal actions of tenants may be unlawful. In fact, there is a federal court case in which a Wisconsin Sheriff's Department was found liable for a pattern and practice of unlawful evictions. And so police departments who are taking a very broad and in some cases inaccurate view of Act 176 may be affecting unlawful evictions. And if they do that with a pattern and practice, there's at least one court case that suggests that they may be liable. Another misconception is this idea that the law has changed and so we've just got to get you out of the apartment. The law has changed and so you need to go. The law requires removal in a very narrow set of circumstances. So for the law to require the police to arrest someone for trespassing, all of the following requirements would need to be met. And these flow from the idea that the police have to have probable cause to believe that the person is committing trespass. So the police would need to be first called to investigate trespass and not for some other reason. The law says, the provision of Act 176 that we're talking about says that police department's involvement in removing trespassers only applies when they receive a complaint for trespass. So if the call was for some other reason, law enforcement, there's nothing in the law that directs law enforcement to take this more active orientation to trespassers. Secondly, the police have to know that this person, this potential trespasser, is probably not a tenant. So they have to do an analysis to determine that it's more likely than not that this individual doesn't have a tenancy relationship with the landlord. So they have to know that the landlord never gave permission for this person to reside in the property. They have to know that there isn't or wasn't a verbal rental agreement or a written lease. That's going to be very difficult for law enforcement to know in the types of situations that we've heard about where they're responding to some other kind of complaint or responding and dealing with domestic violence. Law enforcement is probably not going to be in a position to do that type of analysis. And if they don't do that type of analysis, they won't be able to know that the person is not a tenant. They also have to determine that the person is breaching the peace. And remember, that's an element of the criminal definition of trespass, that the person is remaining or entering the dwelling under circumstances that tend to provoke or create a breach of the peace. Kind of typical landlord-tenant disputes are not circumstances, this is my argument, are not circumstances that tend to breach the peace. When there's a genuine dispute as to whether someone is a tenant at will or there was a verbal rental agreement, the civil eviction process, the civil process that we have, is a way to peaceably resolve those disputes. And so if someone is simply trying to remain in their home, I think there's a very strong argument to be made that they are not breaching the peace by doing so. If someone has a problem with them remaining in their home, the landlord tenant law provides a civil process for that. And then lastly, the police have to know that the person was not invited to enter or remain on the property. And under the facts and circumstances of these types of police calls, that may be very difficult to ascertain to the extent that they would need to say, okay, now we have to remove someone. So all of this information is I'm talking about to kind of lead up into ways in which if you're experiencing these types of issues in your community, you can do some advocacy to mitigate these consequences for survivors and for the folks that you're working with. First and foremost, I think it's important to identify if there are bad interpretations of Act 176 around the removal of trespassers that are causing problems in your community. If they're not, you might want to evaluate whether this is one of those situations where it's best to leave sleeping dogs lie. If a police department is not very active around this issue, you might not want to point out like, hey, there's a new law that says you have to do something different if you're not sure that that will go in a direction that is advantageous. But if there are issues that are occurring in your community and you feel like you have the ability to positively influence it, some things that you can do is to direct those law enforcement agencies to Wisconsin Department of Justice guidance that they recently received that makes many of the same points that I just made about all of the analysis that a responding law enforcement officer would have to do related to landlord tenant law to determine whether someone who is allegedly trespassing in fact is trespassing. I think that if law enforcement agencies use that guidance, it's probably the single most helpful thing that we can do at this point given the state of what the law actually says. The other thing that I think it's important in this context of working with departments and maybe being involved if they are creating these written policies is to remind them something that we hear sometimes to our frustration, right, is that landlord-tenant law is a civil matter. And so if these are disputes about whether someone is or is not a tenant, that's a civil matter that should be resolved by the civil process. And again, we know from our work that in a lot of situations, law enforcement agencies they have at least a momentum or a tendency to want to say that things are civil matters. And in cases where your clients might be being removed from their homes, in this instance, saying it's a civil matter might be a good thing. And then I think it's also important to make departments aware of potential liability if they're taking overly expansive views of when they need to remove tenants or suspected trespassers. The DOJ guidance that I referred to makes that point as well. So if they don't have to take your word for it, they can look to the Wisconsin Department of Justice for that information. And then I think it's always important that to the extent possible to try to find attorneys for victims who are in this type of situation. I know that many folks who practice landlord-tenant law from the tenant side, and particularly folks at legal services, they're interested in this issue and they want to push the law in a good direction for vulnerable folks by making sure that the rights of tenants are fully protected. And so I think there is an opportunity here to make referrals as well. So I know that we've covered a lot of material and there are only a few minutes left. So I'll ask Colleen if any questions kind of collected themselves while I was talking.
Yes, before we get to those questions, I'll just say this concludes our presentation of landlord-tenant law and critical changes that will affect victims of domestic abuse. This was recorded on August 25th, 2016. Again, thanks for joining us today.